Hi, everyone. Welcome to our COVID and unemployment webinar. We usually like to wait a couple minutes before we dive in as some people sort of trickle in a few minutes after the hour. But we'll go ahead and get started with introductions, what to expect, and then we'll jump in. You can, just so everyone knows, like a sort of a tech note, the chat, for those of you who haven't been on my prior webinars, there's an attendee chat feature where you can send me chat messages. And so that's the best way to ask questions for Jacob. I have been compiling our most frequently asked questions, and Jacob's been compiling his most frequently asked questions. So we're going to start with the stuff that we think everybody wants to know. But you should feel free to jump in, send us chat messages if you have more specific questions. I'll be mining the chat. And so as much as we have time to get to, we'll get to it. So I wanted to introduce our very first webinar guest. So please, I hope everyone will be patient with the technology. This is my first time ever hosting like a multi-person webinar. I know we're all kind of learning these new systems and getting used to everything. So hopefully we'll work out without any glitches. Jacob Corder is, in my personal opinion, New York City's top unemployment expert. That's why we invited him on today. We were really excited and grateful that he was willing to join us. Jacob regularly represents claimants at hearings and on appeals before the New York State Unemployment Insurance Appeal Board. And since 2014, through his solo practice, Corder Law, he's handled hundreds of unemployment insurance matters. He also handles discrimination, wage and hour, and other employment law matters. And even before graduating from New York Law School in 2013, Jacob had experience in unemployment insurance law as a Peggy Browning Fund Fellow at the Workers' Defense League and as president of the Unemployment Action Center. I also volunteered for the Unemployment Action Center when I was in law school, so I know how great they are and how much work goes into that. So thank you, Jacob, for that. And I also just want to say that I myself have personally consulted with Jacob on unemployment issues that came, up for me in my own business. And so when I say that I recommend Jacob, I really mean it. He is who I personally have used and will use if I ever experience such an issue in the future. So thank you, Jacob, again. I'll say this again at the end, but just so you know, we're going to make sure that all of you have Jacob's contact information. So you are welcome to contact him with general questions about unemployment. But the best time to reach out to Jacob is if you have any sort of actual dispute when you have a hearing scheduled. So we'll make sure that you have his contact information. But if you end up in a dispute with your employer, whether if your employer is contesting your right to unemployment benefits, that's when you should call Jacob. All right, so I think most of us, well, hopefully you've had a chance to peruse Jacob's really excellent guide, which we also threw up on our own COVID Resource Center website. Oh, sorry, Jacob, did you want to say hi? And
hi, everyone. Thank you, Susan, for the kind words about me. I'm happy to be here and share my knowledge, just with the caveat that this is a situation that's developing and changing every day. So there may be things I don't know the exact answer to right now. There may be things that I think I know the answer to right now, and tomorrow guidance can come out saying something different. But we're doing our best to stay abreast of the situation and share what we know.
Important caveat. Because yes, lots of things are changing. And even as much as we do our best, also definitive seeming guidelines will be issued one day, and then the next day, the opposite guidelines will come out. So we're not just like covering our asses when we say, any information could become outdated. It's true. So just double check, reach out to Jacob, reach out to me, check our websites, and independently verify everything. All right, so I think everyone knows that there's these new expanded unemployment expanded benefits, expanded time frame, expanded eligibility. Jacob, could you start with just sort of giving us an overview?
Sure. Well, let me begin by saying that these new programs have supplemented the existing system, not replaced it. So my assumption is that a significant number of people, even during the pandemic, are going to continue to receive regular unemployment benefits before they would be eligible for any of these other programs. What the new legislation has done is several things. Number one, it has extended for people who are receiving regular benefits, it's extended the number of weeks by 13 weeks that they can receive those benefits. Number two, for a period of approximately 4 months, beginning this week in July, it's increased the amount of weekly benefits that people can receive by $600. And thirdly, it has expanded the coverage. In other words, it's going to provide benefits for people who normally would not have been eligible for benefits, either because of their work history, because of their status as independent contractors rather than employees, things like that.
Great. One of the big questions that we've been getting from a lot of people is, what if you were working part-time,
Right.
or you were full-time and you were cut to part-time? How does that work?
Sure. So the system in New York is a bit counterintuitive when it comes to that. I'll explain what the system is, and I'll start by saying that there's no indication in the current guidance that any of the new programs have changed or created an exception to the system that's already in place. So I'm just going to describe what the law has always been on this, and until we hear otherwise, I'm going to assume that these rules still apply. Um,
You said until instead of
Well,
unless.
I'm hopeful. We've gotten some indications from the Department of Labor that they're sympathetic to the financial situation that people are in right now, and that they're looking to take a liberal approach to granting benefits. How far that's going to extend, I don't know, but I'm hopeful that there may be some carve outs for people to get benefits when under normal conditions they may not have been. But with that said, New York goes by days of unemployment. And according to the Department of Labor, the way they've interpreted the law, any activity on any day that may bring in income at any time, even if you're not actually paid for it when you do the work, is considered work. And if you look in the claimant handbook, there's a section that says what is considered work. And if you read it, you'll see that basically anything other than breathing can be considered work by the Department of Labor. And even an hour or less of work on a day is considered a day of work. So I've spoken to a lot of people who have the misconception that, if they work, um, let's say they work 4 days in a week, 4 hours a day, that's 16 hours. They say, well, 16 hours divided by 8 is 2, so I had 2 full days of work. It doesn't work like that. Any work on a day is an entire day of employment. So for people so there's no specific rule that if your hours get reduced or your pay gets reduced or you're part time, that you're eligible or not eligible. You still have to meet the requirements. So anyone who works 4 or more days in a week, regardless of their earnings, is not eligible for benefits for that week. Separately, anyone who earns more than the maximum benefit rate, which is $504 in a week, regardless of the number of days they work that week, is not eligible. Somebody who does not work at all in a week is eligible for full benefits for that week. Somebody who works 1, 2, or 3 days and earns less than $504 is eligible for partial benefits. I hope that was a clear breakdown.
So the amount of benefits they would get is just the amount that gets them up to 504 a week.
No, it's more of an on-off switch. So if someone does any work in a week and earns more than $504, they can't get benefits that week. If
Okay.
they earn less than $504, then their eligibility for benefits is based on the number of days of work. If they have
Oh,
4 or more days of work, they're not eligible. If they have
okay.
1, 2, or 3 days of work, they're eligible for partial benefits. So, and it gets reduced by a quarter. So if you have 3 days of work, you get 1/4 of your benefit rate. If you have 2 days of work, you get half your benefit rate. If you have 1 day of work, you get 3/4 of your benefit rate. If you have no days of work, you get your full benefit rate.
And is your benefit rate tied to your income or what?
So your benefit rate is determined by looking back at your work history roughly for the last 18 months. They look at what's called the base period. So when you open your claim for benefits, you're in a calendar quarter. Right now, we're in the second calendar quarter of 2020. So someone who opens a claim today is going to have a base period going back to the first quarter of 2019. There's a basic base period and an alternate base period. So the basic base period would be the 4 quarters of 2019. The alternate base period would be the second, third, and fourth quarters of 2019 and the first quarter of 2020. I know this is convoluted, but this is how it works. So they look at your earnings in the base period. I don't want to get too much into the weeds on the math of it right now, but to make a long story short, they look at your earnings in the base period. Could be from one job, or it could be from multiple jobs. And if you have the requisite earnings in the requisite proportions within your base period, you can then open a claim, and they use those numbers to determine your benefit rate.
Gotcha. Now, a lot of people have been asking, how do I determine my income if I'm a freelancer, independent contractor, I'm not a traditional W-2 employee, or maybe I'm a sole proprietor or self-employed.
Okay, so the what I would start by saying is I've gotten a lot of anxious calls from people along those lines. I don't think people should get too hung up on how they determine their income. I think the focus should be on accurately reporting any money that they receive for work to the Department of Labor. The Department of Labor will make a determination, and then if there's a disagreement, that can be resolved later through the hearing process. But in terms of how the Department of Labor will determine it, if it's someone who's not eligible for regular benefits, it's going to be very similar to the process I just described, with a few tweaks. The first tweak is that the base period is automatically going to be all of 2019, the 4 quarters. The second tweak is that income that normally would not be considered remuneration under the law, such as 1099 independent contractor income, will be treated as income as if it was W-2 wages for the purpose of the pandemic unemployment program. And number three is that the minimum benefit rate for the pandemic unemployment is actually slightly higher than the minimum rate under the regular state law. But other than for the people who fall below that minimum and get bumped up, their rate will essentially be what it would have been if all their 1099 income had been W-2 wages. Does that make sense?
Hmm. What if you're off the books? First of all, do you just give them your best faith estimate? And also, is there any chance of, if well, I guess you could have just not filed your 2019 taxes yet. There's a common question of, say I'm a nanny and I'm paid under the table. What should I do?
Right. So it is possible for people who worked off the books to get benefits, but of course you have to satisfy the Department of Labor that you actually earned what you say you earned when you say you earned it. Um, Now, in terms of people who haven't filed 2019 taxes, there are alternative ways in the regulations, to provide equivalent documentation to prove that you received the money you say you received. When it comes to off the books work, it can be difficult because you often would have an employer who doesn't want to report that work and those wages to the Department of Labor. If it doesn't get sorted out, you could end up having to go to a hearing, where the employer says this person never worked for us, and you have to present evidence to the judge that you did work. And obviously, what that evidence is going to be is going to vary on a case by case basis. But the short answer is yes, as long as you can prove that you did the work and received the wages, the Department of Labor will consider that. But it's considerably harder to establish that than when you just have straightforward, wages that have been reported. And I'd also note that, while obviously the immediate concern for many people is to get income and to get unemployment, obviously reporting off the books work could have other consequences in terms of taxes, possibly immigration. So I would urge people to consult their advisors in those areas before doing that, to make sure that getting the unemployment in the short run is not going to open cans of worms in other areas in the long run.
Mm-hmm. Let's talk a little about the employer's role in this process. A lot of people ask, do I need to present proof from my employer that I was laid off or terminated? At what point does the employer have the opportunity to contest my unemployment? Why would they contest it? And then what's the time frame? What would the next steps be?
Sure. So my position is that the employer should have little to no role in it. Only the Department of Labor can determine eligibility for benefits. I've even seen a few cases where an employer actually comes to the hearing and says, "Judge, we want this person to get benefits," and based on the law, the person still gets denied. So I understand that there's an urge for people to try to work with their employers, or perhaps even get advice from their employers about their eligibility. I would discourage that, and I've actually heard recently of employers telling people they're not eligible for unemployment when, in my opinion, they actually should be eligible. So the focus should be on providing information to the Department of Labor. And if the employer wants to provide different information to the Department of Labor, they can do that, and you'll have a chance to respond. There's no magic document that you need from an employer. The Department of Labor is going to look at the facts, the reality of what the situation is. Documents really only come in when there's a dispute about credibility. So, for example, if you tell the Department of Labor you were terminated, and the employer later says, no, you resign, obviously, if you have a termination letter to show the Department of Labor or show the judge, that's going to make your version more believable. But there's no specific document or specific language you need from an employer to open a claim. You need to accurately report the facts to the Department of Labor. In terms of why an employer would protest, there's two reasons. One reason, frankly, sometimes it's a matter of principle, and employers just get annoyed that someone who worked for them, who they think isn't deserving of benefits, is trying to get benefits. The economic reason is that the unemployment insurance system is funded by contributions from employers. It's a pretty common misconception that employees are paying into the system from their paychecks. They shouldn't be. That's not allowed. So employers pay in, and then if a former employee gets benefits, the employer's account gets charged, and it's an unbelievably convoluted system. The short answer is that the more former employees that get benefits, the more the employer has to pay into the system going forward. Have a financial incentive to minimize former employees getting benefits. In terms of the time frame, which I think I'm hitting on all the parts of your question, under normal conditions, it could usually take just a matter of weeks, for the notices to go out, for the Department of Labor to investigate and issue a determination. Right now, what we're hearing is that the system is completely overwhelmed. People can't get through. At least some of the staff at the Department of Labor may not be physically reporting to work. So I would expect that, and also I would note that if notices are going out, it's possible that employers whose businesses are closed are not access their mail. So I would imagine things will be moving much slower now. and things that would have happened quickly before may be happening much later.
When you mentioned a minute ago, if the employer disputes whether there was a voluntary resignation. Now, I know that the new pandemic unemployment assistance has new guidance about if you quit because, well, I don't know. Tell us about what if you quit because you were afraid of getting coronavirus from your workplace, or you, for some reason, you felt like you couldn't continue to work and it was associated with the coronavirus.
Right. So, under normal circumstances, someone who voluntarily leaves their employment has to establish that they did so with good cause in order to receive benefits. My understanding of the law would be that normally leaving because of some kind of abstract fear of something happening in the future generally would not be good cause. Now, obviously, the pandemic unemployment assistance has expanded the reasons that someone can be eligible. And the guidance from the Department of Labor very generally uses language along the lines of quit employment and affected by COVID 19 or quit employment because of COVID 19. I have no idea how that language is going to be interpreted. My opinion, and I tend to be very conservative in the advice I give to people about this, I would not assume with any degree of certainty that quitting because of a general fear of getting the virus, where you have no symptoms, no advice from a medical professional to quit, no specific concrete way that it's actually affected you, I would I would not, if you quit under those circumstances, I would not assume that you're going to get benefits. I think there's an argument to be made that if the law is interpreted broadly to achieve its intended purposes, that those people should get benefits. But there's no clear guidance that that's the case at this point.
Would you suggest somebody in that situation get what if they can get documentation from a medical professional? Do you think that would be helpful?
Yes, generally, when someone is quitting because of a medical reason, the gold standard is having a note from a doctor specifically saying, at the time that the person quit, I advise my patient to quit their job because of such and such health condition. There are some cases where if someone knows that they have a pre-existing condition, where the appeal board has made exceptions. So I think it would be a much stronger argument if a doctor is actually advising someone to quit, especially if it's because they have a condition that makes them vulnerable, and that advice can be documented. I think that would significantly increase the chances of someone being found eligible in that case.
Great. All right, we have actually a surprisingly large, in my opinion, number of people asking about a specific situation where someone has had a variety of different roles, say, in the course of the past year, where maybe they were on a W-2 for a period, but they also have their own company, maybe where they remained an officer, whether or not they were deriving income from their own entity. Um, so maybe I have a side hustle, selling something on Etsy or whatever. I also have had a day job and I got laid off from my day job. Is my side hustle going to have any sort of negative repercussions? How do I deal with that situation?
It's very likely to have negative repercussions. And I think this is something that is perhaps getting lost in a lot of the discussions about this new law. It expands the amount of benefits, it expands who can get benefits. It doesn't change the fact that unemployment benefits are for people who are unemployed. Right now, in the absence of guidance that says otherwise, we have to assume that the New York State law and all the normal rules about what constitutes unemployment are going to apply even under these new programs. Um, so for someone who, if we're talking about W-2 work, we're talking about what I said earlier about the 4 days and the 504. For someone who is self-employed or has a business or is an officer of a corporation, the Department of Labor and the Appeal Board take a very unforgiving approach in those cases. So someone who has an ongoing business from which they stand to gain financially, even if they're not actually gaining financially at the time, or they're not actively working full time on the business, can very likely be found to be employed under the definition in the law. And there are cases where even things like going to open mail or writing checks or updating a website, very passive things that may not generate any income at all, are enough to establish that the person is involved in an ongoing business. Again, it would be great if we get guidance saying that those rules are going to be relaxed because of the financial despair that people are in. But until we see guidance like that, I would say anyone who has an active, ongoing business, even if it's not a profitable business right now or at all, should really think very carefully before applying. Or if they do apply, they should at least accurately report their situation to the Department of Labor, so that the Department of Labor can evaluate and not later hit them with penalties for concealing the fact that they had a business.
Mhm. What say somebody left the state because of the coronavirus? They went to go live with their parents or whatever. Can they still apply in New York? Do they have to apply in the other state? How does that work?
So where you apply is based on where the work was. Um, Generally speaking, it's pretty easy to determine that. There have been cases where you have to kind of get into the weeds on that, especially in the era of remote work. It's not always clear. But if the work was done in New York, they should be applying in New York, regardless of what state they're in. One caveat with that, though, is that another rule, which, as far as I know, has not been lifted for the pandemic, is that in order to claim benefits, regardless of whether you have the requisite work, regardless of whether you quit with a good cause, regardless of all the other stuff, if you're outside of the United States, Canada, Puerto Rico, or the Virgin Islands, you just as a matter of law, you're deemed not available for work. Even if you're doing work, even if you're looking for work, legally you can't certify, you can't claim, and if you either use technology to circumvent the system that stops you when they see a foreign IP address, or you give your login information to someone who is in the country to certify for you, A, in most cases, the Department of Labor will find out, and B, the penalties are quite strict for that.
Okay. Is if somebody left their job before coronavirus hit, and so now they're unemployed, but they're not unemployed because of the coronavirus. Can they still take advantage of the new pandemic assistance?
So, I mean, first and foremost, in order to even be considered for the pandemic assistance, you first have to be found ineligible for regular benefits. And as far as I know right now, there's not even a separate application for the pandemic program. The Department of Labor is saying that you have to apply for regular benefits and be denied before you get into the other program. So, someone who their job equally would have or could have.
Wait, sorry, wait. You just cut out for 1 second. So,
Sorry,
no,
what was the last word?
um, that as far as you know, there's no requirement that you like go through it twice.
Right. So everyone is starting out by filling out a regular application for benefits, and then only after someone is deemed ineligible for regular benefits do they get put into the pandemic program. So someone who quit prior to the COVID-19 or for a reason unrelated to COVID-19, my position at this point would be that they're still subject to all the regular rules, whether they quit without good cause, whether they're totally unemployed, and that those determinations continue to be made. Because the pandemic unemployment assistance only applies to people who have COVID-related reasons, I would say that if someone quit for a reason unrelated to COVID and is found ineligible and is disqualified, most likely they're not going to be eligible for the pandemic unemployment. Now, if you read the language really, really liberally, you could make an argument that even someone who's disqualified under the regular rules could go into the pandemic program. But based on what I've seen so far, I'm not at all confident that that's the case.
Since a lot of these questions boil down to, am I going to be able to get the benefits? Is there any reason for those people with those questions not to just go ahead and apply, and the worst case scenario is they get denied?
No, with the caveat that there's nothing to lose as long as you accurately report your situation to the Department of Labor. If you
Mhm.
accurately report everything and they deny you, you'll be in the same position as you'd be in if you don't apply. If you conceal or misrepresent your situation to the Department of Labor, you could end up receiving benefits that later you have to repay. You could be subject to monetary penalties, and you could be subject to a loss of future benefits as a penalty. And at least theoretically, in some extreme cases, criminal penalties, although it's extraordinarily rare that that actually happens.
Still better to avoid the specter.
I don't see any reason not to apply, but I would caution against an urge to just go into the application, check all the boxes off that you think are the right answers just to get the money as quickly as possible.
Right. Okay, just so everybody knows, this recording will be available. So if you missed part of it, we're going to send out a link. You'll have this presentation, you'll have Jacob's materials, you'll get everything by email. So if you missed something, you'll be able to go back and watch it later. So let's talk about the extra $600 a week. Is that for everybody? Is that dependent on income? How does it work?
So it is for those who are eligible, it's a flat additional $600 on top of whatever you would be getting. But it presumes that you are either getting regular benefits, getting the additional 13 weeks of benefits, or getting the pandemic unemployment assistance. If you're getting one of those things, whatever your rate is under the established rules, $600 will be added to it from April 5th to July 31st. But you still have to be getting benefits in the first place. In other words, if you're not eligible, you don't just get $600.
Right. Now, is the $600 chopped off proportionately by the day of number of days worked that we were talking about earlier?
No, based on what we've seen so far, it's simply whatever you're getting, as little or as much as it is, plus $600, period.
Great. Okay, I'm scrolling through the questions as we talk. Okay. Let's talk for a second about seasonal. Oh, wait, no. We'll come back to that. Or yeah, let's go ahead. Seasonal workers. How does it work? If someone was a seasonal worker, say April to September, they work most years, and so they haven't been working for the past few months, but they were expecting to be able to resume working around now, and they can't.
The same rules apply. It's based on. I mean, first of all, you have to have the requisite wages in the base period, all of that. But if you lost your employment for a non-disqualifying reason, you're ready, willing, and able to work and looking for work, that that's what matters.
Okay.
So generally, if seasonal employment ends and there's just no work available, that would be a lack of work, which would be a qualifying reason. Now, if the person says, "Well, I only want to work seasonally and I want to stay home the rest of the year," then they're not ready, willing, and able to work. But if they are looking for other work and they otherwise meet all of the requirements, the fact that it was seasonal employment shouldn't make a difference.
What about employees who are on furlough? So they're not getting pay, but they're still not getting their benefits.
Right. So the same, as far as I'm concerned, the same rules would apply. We have to look at whether they're performing any work on those days in the week and whether they are receiving $504 if they are working. Um, Unemployment looks at a lack of work. There's no magic word for furlough or layoff. It's whether there's work available, whether the person is working, and if so, how many days and what they're earning. So if someone is on furlough, but there's no work available for them, they're not doing any work, they're not earning any wages from work, I would imagine they would be eligible.
Okay. So their income like if let's say the employer said, okay, you're furloughed for 2 months, so you're unemployed for 2 months, but we're going to keep paying you either some amount of cash or some amount of benefits. Does that income count toward, like, could that income be disqualifying, or because you're out of work and you're not working, you're just it doesn't count because it's not wages for your work?
It's tough to answer that question. Generally, it would really require looking at the income, looking at the somewhat extensive definition of remuneration in the statute and all of the exceptions to it, and determining whether the payments that are being received actually constitute remuneration under the law. So I don't want to give a general answer that may mislead people.
Okay, fair enough. What if somebody was laid off and they received, tell us about a little bit about how can severance payments affect your eligibility for unemployment, if at all?
Sure. So, since the law was amended in 2014, this has been a big topic. The first thing that I want to make clear is that these rules only apply if the first payment of severance, it could be the first of several or the first and only, if the first payment of severance is made within 30 days of the, excuse me, of the last day of employment. If the first payment of severance is not made until more than 30 days after the end of the employment, it doesn't matter. It could be $1 million in severance, it has no effect. If we're within that 30-day window, then you have to look at a couple of things. So, first of all, if it's a lump sum, you have to allocate it based on the weekly wage. Just as an example, if someone has an annual salary of $52,000 a year, that's $1,000 a week. So if someone receives a lump sum severance of $10,000, that severance is deemed to have been received over a period of 10 weeks. The second thing you have to look at is whether the weekly amount is more than 504, which, given the nature of severance payments, it usually is. If it's more than 504, and if it's within the 30 days, you cannot claim benefits for whatever number of weeks that severance payment covers. After that number of weeks has elapsed, if you still otherwise meet the criteria, you can then open a claim for benefits. And if you're still unemployed, you can still get your full 26 weeks. You just can't start getting them until after that severance period has passed.
Um, uh, can a sole proprietor apply for unemployment? Yes, right? I feel like
Well, it would depend. So the actual label of sole proprietor has no meaning in terms of the unemployment insurance law. If what we're talking about is a sole proprietor who's self-employed or is an independent contractor, they would be treated the same way as someone who has a corporation or an LLC, which would mean normally self-employment would not uh, count in terms of establishing a claim. And if you're actively self-employed or actively have a business, like I said earlier, you would not be considered to be unemployed. But there's no particular distinction between a sole proprietor or someone that has an entity. And under the excuse me, pandemic unemployment assistance, a sole proprietor who is actually unemployed would be able to use their wages from their or their money from their sole proprietorship to establish a claim based on that special temporary program.
so. Okay, tell me if I have this right. if I say I'm a business owner and right now I'm not seeing any income from my work, but I do have work that I can do. I can send out marketing emails, I can do advertising, all that stuff. Um, should I, if I have 10 hours of work a week that I could be doing, does it make sense to cram all of the work into one day? So I'm working one day a week and I can get more days worth of unemployment?
There's a slight possibility that it makes sense, but the reality is that in most cases, if you're in that situation where you have an ongoing business from which you stand to gain, you're going to be deemed to be employed during the entire period of time, even if there are discrete days on which you're not doing work. I have seen cases where if it's a really unique situation or it's a business that's being wound down and you can really establish that specific activities were only being done on one particular day, you can make that argument. But in general, the rule of thumb is that if you have an ongoing business, you're employed while you have that business, regardless of the number of days, regardless of the money it's generating. Now, if you are an employee or an independent contractor working for someone else, not your own business, in that case, I think it makes a lot more sense to try to condense your hours into as few days as possible. And obviously, assuming you're earning less than the 504 for the week.
So let's take my previous hypothetical side hustle on Etsy. Is it better for me if I'm like, okay, I have this Etsy store, but nobody's buying anything, right? Like right now, nobody wants to spend money on my products. So should I sort of formally close up my shop and put up a notice saying, hi, everyone, we're not selling our products right now, because then I don't stand to gain the income from my business and I can apply for the unemployment?
So, unfortunately, it's going to be another not so black and white answer. In terms of total unemployment, yes, closing down the shop, dissolving the entity if you have one, doing absolutely nothing for the business makes it better to argue that you're unemployed. The problem, though, is that you still have the issue of potentially being disqualified for leaving employment without good cause. And that can include not only resigning from a W 2 job, but also abandoning a business that is still financially viable. There are cases where someone has closed down a business and the Commissioner of Labor wants to look at tax returns, and you essentially have to prove that there was no possible way to continue the business and make it viable, because then you could end up being in a situation where you say, okay, I'm totally unemployed, but the commissioner says you're disqualified because you left your employment without good cause. So it's tough, but it, yes, closing the business down would make it more likely that you'd be eligible than not closing the business down.
Okay. But it sounds like a better option for all of these hustlers is to go apply for the other loans and grants.
Yeah, look, there are undoubtedly going to be people applying for and frankly probably getting benefits, even though they could have availed themselves of work or business opportunities. Um, Frankly, I would love to see guidance saying that I could get the benefits because my law practice has slowed down because of the pandemic. But I think if people are approaching this from the idea that, well, I have work or I have an opportunity for work, but how can I sidestep it to get the unemployment? In my opinion, that's too risky. And while it will probably work for some people, for others, it will result in having to repay benefits and penalties. And on top of the benefits and penalties, potentially having walked away from a work opportunity that could have been valuable. So I'd be very discouraging of that approach.
Okay. We are out of time. Thank you so much, Jacob.
You're
Um, this really clarified a lot of things for me, hopefully for everyone else. I tried to get to as many questions in the chat as I could. We will be sending out a link to everyone with our contact information and this presentation. If there's any questions we didn't get to, I'm going to try and reach out to you individually to address your questions. But otherwise, please stay in touch with us, and good luck and hang in there.